So, hello, and once again, welcome to Introduction to Criminal Justice. Today's lecture, we're discussing the structure and functions of the courts. So, I'll give you a brief introduction to American courts. If this is something that interests you, you can take judicial process with me. I wrote the textbook for it. It's one of my favorite courses to teach because we really get into depth. But here, we're just going to kind of glaze the surface, right? So, United States, we have a dual court system, right? So we have state and federal courts. That's what we mean by dual. And we've talked about, we actually have 51 systems, and but the dual court system notion still plays, right? There's state courts and there's federal courts. Now, whenever something happens, right, the ability of a court to hear a case is called its jurisdiction, right? So you've probably heard that used in many different contexts, specifically when we're talking about like police. It's on the police's jurisdiction. The same kind of holds true for courts. Jurisdiction is a really, really big issue. It's something you have to basically prove to the court before you can move forward with a lawsuit. You have to prove to the court that the court has jurisdiction, has the ability to hear the case. So that being said, when we think of jurisdiction, there's really three types that we should think about and appreciate. Right? So we have courts of limited jurisdiction, courts of general jurisdiction, and courts of appellate jurisdiction. Now, courts of limited jurisdiction, they try to monitor, or they try minor offenses and other limited duties to assist the courts of general jurisdiction, right? So, and this is criminal justice, so obviously in a criminal context, they're dealing with misdemeanors, like minor misdemeanors, that would basically clog up the courts of general jurisdiction. We'll talk about that in a minute. So this is stuff that it's really petty for the most part, and the goal is to not, put too much on the courts of general jurisdiction. We give limited jurisdiction. We say, okay, this court, you can handle all these cases, right? They're misdemeanors. Generally speaking, courts of limited jurisdiction deal with 90% of all criminal cases, right? So again, this kind of comes back to our idea of like violent crime and crime rates. Most crime, 90% of it is that, again, we have the dark figure of crime, of course, but 90% of known crime is misdemeanor. It's minor, right? Courts of general jurisdiction won't usually handle this. I'll say this from at least my experience. You usually get 2 bites at the apple before they put you in jail. So you can get like probation and then probation again, and then you'll get jail time. Like, don't go out and start committing misdemeanors, but just know that, I mean, that's what ends up happening, right? In 90% of all cases, that's how they get resolved in these courts of limited jurisdiction. Now, when we think of like trials, right, like long, lengthy trials for things that are severe, we can think of courts of general jurisdiction, right? So courts of general jurisdiction, they try the major trial courts. They can try and decide any case, even if it's a minor one, including appeals from a lower court, right? So if you don't like the outcome of what you get in the court of limited jurisdiction, which can put you on trial, right? You can go to trial in court of limited jurisdiction. You can appeal it to the court of general jurisdiction and may be able to hear it or something along those lines. So that being said, when, at least, and again, my experience, I practiced in Massachusetts District Court, which is a court of limited jurisdiction. And most often we would appeal cases to the court of general jurisdiction if bail was too high, right? So we'd get bail set in a court of limited jurisdiction, and then we would say, well, that's ridiculous, we can't meet that. So we appeal to the court of general jurisdiction and have basically a new hearing. So that being said, because courts of general jurisdiction deal with major cases and appeals from the lower courts, due to the seriousness and the number of these cases, these are called courts of record, right? So basically, in district court, you don't necessarily have a stenographer sitting there typing down everything that people say. Mostly it's recorded nowadays. You can actually like live stream it if you want to at any time, but it's not necessarily recorded. Courts of general jurisdiction, they'll always be recorded, right? You'll have a stenographer, it'll be tape recorded, it'll be everything so that we know verbatim what everyone said and what everyone did because the cases are so severe. And then finally, we have courts of appellate jurisdiction. Appellate jurisdiction is limited to matters of appeal from lower and trial courts, right? So I say lower and trial courts. Usually we're talking, if we're going to a court that has appellate jurisdiction, usually we're talking a decision that was made in the court of general jurisdiction and any lower courts. So if it's a state Supreme Court, it has appellate jurisdiction over appeals from the state court of appeals. So that's what we mean when we're talking about a lower court. So to kind of give this a better view, to understand the different types of jurisdiction, right? So we have the dual court system in front of us. On the left-hand column, we have the state courts, and on the right-hand column, we have the federal courts. Right? So we start with courts at the very bottom, right? These are the least severe courts of limited jurisdiction. And state courts, we call them magistrate courts, justice of the peace courts, municipal court, county court, district court, etc. They're at the very bottom, right? They're like it's peanuts at that place. If we want to talk about courts of general jurisdiction, if we're talking federal courts, this is the U.S. district courts, right? And we'll look at how we define districts and appellate jurisdictions in a little bit. If we look on the left-hand column, major trial courts, it just depends on the state. So the state might call it a circuit court, may call it a district court, may call it a superior court. Like I said, Massachusetts, it is in the lower courts, district court, and the major trial courts is superior court. So there is no real general consensus. You can't just say, oh, superior court, this has to be this, because it's not necessarily true. But you should know basically the different types and how they'll be referred to. So we have these courts of general jurisdiction, right? And then we move up to basically two prongs, right? Courts of appellate jurisdiction. So if you don't like the outcome of what you get in U.S. District Court, you appeal to the U.S. Court of Appeals. Okay? And if you don't like then that's an appellate jurisdiction. And if you don't like what the Court of Appeals says, you can appeal to the U.S. Supreme Court. On the left-hand side, if you don't like what the major trial court said or did, you can appeal to what's usually called an intermediate appellate court. These will often be referred to as the state court of appeals, right? So Missouri Court of Appeals, Massachusetts Court of Appeals. We'll talk about New York. New York's a little different. And then if you don't like what you get at the Intermediate Court of Appeal, if a state even has it, you can go to the state court of last resort, right? This is usually called the Supreme Court or the Supreme Judicial Court or something along those lines, but it's the court of last resort, right? So it's like, this is the highest that you can go. Now, we'll talk about this a little bit. If your case raises a federal issue or constitutional question, you can also appeal it to the Supreme Court. But you can't just appeal anything to the U.S. Supreme Court. And most cases don't involve constitutional issues. So that kind of gives you an idea of what I'm talking about, appellate courts and general jurisdiction and limited courts. I think the visual is good, right? Limited jurisdiction means they can only handle certain things, very minor. Then you have major trial courts, they deal with the big stuff, they deal with the not the bulk, because the bulk is down in limited courts, but they deal with the very serious, we're looking at prison time courts, right? Then courts of appellate jurisdiction, they're usually the Supreme Courts or intermediate appellate courts. So let's talk a little bit about the history of the federal courts. If we look at the US Constitution, Article 3, it establishes the Supreme Court of the United States. And so you'll often see it referred to as this acronym, SCOTUS. We call it SCOTUS or SCOTUS. So if you hear somebody say SCOTUS or SCOTUS, they're saying the Supreme Court of the United States. And it gives Congress the ability to establish lower inferior courts, right? So if we look at the US Constitution, Article 1 is the longest, and it deals with basically the Congress, what the powers are that Congress has, because the founding fathers thought that Congress would be the most important branch of government, right? And then Article 2 deals with the presidency. And it's a little bit shorter, but it's still pretty lengthy, right? And they thought that that branch of government would be very important, but not necessarily as important as Congress. And then Article 3 establishes the federal courts. Article 3 is roughly 2 paragraphs long. Basically, the founding fathers kind of dismissed the court as just, well, we need something here, but they're not going to have a lot of power, right? So they didn't vest the court with a lot of power. Instead, what they said is, we'll establish a Supreme Court, and it can hear certain cases, and it can be an appellate court and have appellate jurisdiction. And what we're going to do is we're going to say, Congress, if you need to establish lower courts, if you need to establish trial courts, courts of limited jurisdiction, courts of general jurisdiction, whatever, you can do so in your discretion. So after the Constitution is ratified, in 1789, the very first thing that Congress passes is the Judiciary Act of 1789. And it established lower trial courts, right? And in conjunction with the Court of Appeals Act of 1891, Congress established a 4-tier structure. So this is kind of in reverse order. They have, in federal courts, you have the magistrate courts. These are courts of limited jurisdiction. Magistrate courts deal with misdemeanors, bail, and they assist district courts in legal matters to whatever the district court gives them. So we'll talk about how you become a magistrate, but generally speaking, if you commit a federal misdemeanor, you're going to a magistrate court. It's not a big deal. Like, federal courthouses are terrifying, but magistrate court's not a big deal. Where you know you're in trouble is if you get to the district court. District court, they have general jurisdiction, right? So this is the trial courts. There are 94 trial courts at the federal level in the United States. And we'll talk about how they're broken up in a moment. Congress also established the lower appellate courts, called them circuit courts. So there are 13 intermediate appellate courts, each located in a circuit. You may be saying, what on earth are you talking about? Don't worry, I have a picture. But there are 13 intermediate appellate courts, right? So I worked for the US Court of Appeals for the First Circuit. There's a US Court of Appeals for the Second Circuit, US Court of Appeals for the Third Circuit, etc. Right? And that's just below US Supreme Court. Now, currently we have 9 justices on the US Supreme Court. They're nominated by the president and confirmed by the Senate. This is going to be generally true of most judges in federal courts, with the exception of magistrate courts. Now, what's interesting about the 9 judges, and you may be hearing this, especially in regards to the election, nowhere in the Constitution, or really set in stone, does it say we have 9 justices on the Supreme Court. We started out with 3, and we just kind of grew from there. That being said, FDR during the Great Depression, his legislation, his New Deal legislation, kept getting shot down. So he threatened to what we called court packing the court. Basically, he said, for any justice that's over 70 years old, I'm going to appoint a new justice to help them out, right? But they'll get a full vote. And the idea was he would put his number of justices on the court, and that would be enough to get his legislation passed. It was an extremely unpopular move, but one of the justices actually switched sides. And it's called the switch in time to save 9. Now you're hearing about this in terms of the debates. If you've watched the presidential debates, if we're going to go back to court packing, that's going to be a new issue. So that'll be interesting to see how that plays out. But that's what court packing is. So when I say the hierarchy of the federal courts, right, this is what it looks like. At the very bottom in the orange, you have the U.S. magistrate courts, right? They're dealing with kind of the not really important stuff. I mean, not the severe stuff. Then you have specialized courts. If you look on the right side of your screen, you have like commissions and boards that rule on trade. You have the Court of International Trade and the Court of Federal Claims. They're very specialized courts that just kind of deal with their own thing. And since this is criminal justice, we don't pay too much attention to them. Now, the U.S. district courts, so we have 89 regional courts, 1 court for the District of Columbia. We also have 1 court for each of the territories. So there's a U.S. District Court for Puerto Rico, Guam, Virgin Islands, and Northern Mariana Islands. Now, sitting above them in an appellate capacity is the U.S. Court of Appeals. There's 11 regional circuits and 1 circuit for the District Court of Columbia. All right, so Washington, D.C. has its own Court of Appeals. On top of this, and of course, you have the Federal Circuit, which kind of deals with the trade claims and the federal claims. And then you get to the Supreme Court, right? And the U.S. Supreme Court is the highest court in the land. They're the final arbiters of the Constitution. So they decide what the Constitution means, how it applies, etc. Right? So that's kind of the hierarchy. Magistrate courts, bottom, district courts, above them are the trial courts, then you have the courts of appeal, then you have the Supreme Court. Now you'll notice kind of in the top right-hand corner over here, we have U.S. Courts of Military Appeal. So I worked for the Coast Guard for a little bit, prosecuting sexual offenses. It was interesting because the Coast Guard would prosecute and the Navy would defend. Now, we're talking court-martials, right? That's what they call trials in the military, is court-martials. So we'd have a court-martial, which is a full trial, usually in front of a panel of judges, and then they decide, you know, if you've committed a criminal offense, what's going to happen to you? You're going to go into the brig, right? You're going to go into Leavenworth, Kansas. You know, Fort Leavenworth, that's where the military prison is. But you can appeal, right? And you can go to the U.S. Court of Military Appeals. But that is the highest that you can go to. If you are in the U.S. Court of Military Appeals, you cannot appeal to the Supreme Court. It just is what it is. So this is when we're talking about the structure of the federal courts. Again, you know, I said we had circuits, and then we had districts, and it kind of all seems jumbled up, right? So we'll do it this way. We'll start with the number 1, right? The First Circuit. So if you look all the way on the right-hand side of your screen, you see in the light orange, Maine, New Hampshire, Massachusetts, Rhode Island, in orange. Now, each color on this map represents a circuit, right? So each circuit has 1 appellate court. So each state will have a district court, and this all falls under the Supreme Court. So kind of think of it this way, like each state is going to have magistrate courts in it. It's going to have at least one district court, and we're going to look at those lines in a minute. And then above them will be one appellate court, right? So if we look at the Second Circuit, you have New York, obviously that's where we're at, Vermont, and New York is divided into northern, southern, and western. And we'll talk about that when we kind of get into a better picture. Now, one thing you might have noticed is at the bottom of your screen, Puerto Rico is in the same color as Maine, New Hampshire, Rhode Island. It's because Puerto Rico falls within that circuit. All right, so the colors do match. It's not a trick. If you're in Puerto Rico and you want to file an appeal, you file the appeal in Boston, Massachusetts. It's where the court sits. Now, the judges travel, and each basically court or each territory or each state gets one judge on the Court of Appeals. So why does Puerto Rico in with Massachusetts? I mean, that's a crazy long way. The honest answer is when the courts were formed, most of the sugarcane crop in Puerto Rico and most of its exports were owned by companies that were headquartered in Boston, Massachusetts. So it was just easier to do it that way. The same thing becomes true with the Virgin Islands, and we'll talk about the Ninth Circuit. It's a crazy place. But that's kind of how we generally see things play out. So if you look at the very middle of your screen, and we kind of look and see there's all these colors, and they're all different circuits. We look in the middle of the screen at Missouri, right? Very middle of the country. It's in the 8th Circuit, right? Because that's what the number says. It has Iowa, Nebraska, South Dakota, North Dakota, and Minnesota in it, as well as Arkansas. But you'll see Missouri has this line, right? This is a weird, jagged line through it. And what that means is there's an Eastern District and a Western District. So there are, at minimum in Missouri, 2 district courts. And there's actually a third one in Springfield, Missouri, but it serves the Western District, right? So that's how we divide districts. That's why we can say there's 50 states, but there are 94 districts. It's because we look at these lines and say they're divided. Now the question is, why would we divide these states up, right? Because we've already divided them by color. So we've already divided them by appellate jurisdiction. Why do we need to divide them up further? Well, we divide it based upon populations, right? So if you're not familiar with Missouri, the western side, you have Kansas City, Missouri, which is a big population. On the eastern side, you have St. Louis, Missouri, right? A very large population. Up north, there's basically nothing. Down south, you have Springfield, which is a mid-sized city, and basically nothing. And so the idea here is, okay, Kansas City and St. Louis, they're not close to each other. It's difficult if you get charged with something, you get up there all the time. So we try to distribute the workload and distribute the burden that it places upon people who are in district court to travel, right? So it more or less tries to make it so that you have a court close to you and you don't have to travel. Now, if we look out towards the left-hand side of the screen, out west, and we see the 10th Circuit and the 9th Circuit, and you'll see that, like the 10th Circuit, you have New Mexico, Kansas, Oklahoma is divided up. Colorado, Utah, and Wyoming aren't. And the question is, why aren't they divided up? Because nobody lives there. There's no reason to divide them up, right? You have Denver, Colorado, and that's basically it. Provost, Utah, and then that's basically it. Cheyenne, Wyoming, and that's basically it, right? So I mean, it's literally just based around population centers. It's kind of interesting. You can kind of see the progression of our country if you look from the First Circuit down through the Ninth Circuit, all the divisions, and then suddenly we stop dividing, right? The flyover states. Then you get to California. California has a northern circuit or northern district, an eastern district, a central district, and a southern district. Right? And the reason I have the southern district is it borders Mexico, and that's where we'll get to that later. But we have southern district, central, northern, eastern, right? And you see it's a weird kind of divide. It's around population centers, right? So I mean, you have LA, you have San Francisco, you have San Diego, you have very large population centers. So that's how we've kind of divided that up. I mean, the farther north you go, the less people there are, but that's why we draw the lines the way we draw the lines. They do not follow elections lines, right? So they don't follow gerrymandering or anything along those lines. These lines are purely population-based. That being said, the Ninth Circuit has Arizona, California, Nevada, Idaho, Oregon, Washington, Montana, Alaska, Hawaii, the Marshall Islands, and Guam. Or sorry, the Mariana Islands and Guam. The Ninth Circuit is the pain in the butt circuit. It's the one that if you are in the Ninth Circuit, this is where all the controversial cases comes from, right? So this is where the marriage equality cases came from, was the Ninth Circuit. Because the Ninth Circuit tends to be known as the most liberal circuit, specifically California, coming from California, tends to be the most liberal circuit. And so they raise really big issues, and then once they raise issues, then the Supreme Court kind of has to weigh in on them and be like, all right, we'll make the decision. But the Ninth Circuit's kind of notorious for generating controversial opinions that the Supreme Court will deal with. Now, the Supreme Court can take any of these cases, right, from any of these places, and they do. But the Ninth is kind of the problem child. The rest of them, you know, you can appeal to the Supreme Court, but it doesn't mean it's going to take the case. So let's look at federal criminal cases. This is 2011. What they deal with, right? So if we're looking for what are we dealing with in federal court, 36% of federal court cases are immigration offenses, right? So 36% of what we do in federal court is just deal with immigration, right? Followed fairly closely by drug offenses, right? And that's 20%. So 56% of what we do in federal court is immigration offenses, drug offenses, and if you want to go up to close to 70%, property crimes, right? So not really anything violent, right? Our violent offenses, we're talking 3% of what the federal courts deal with are federal offenses. 6% are traffic offenses on federal land. So you're in a federal or a national park and you're speeding. You get counted as in this statistic. Then we have regulatory offenses, they're 2%. I mean, those are the minor things. Miscellaneous crimes, 2%. And then sex offenses, we're looking at 4%. Justice system offenses, 1%. So the thing that kind of gets everybody really worried, right, is violent offenses and sex offenses. Combined, they equal 7% of what the district court deals with, or what federal courts deal with. Right? Most of what they're dealing with, the bulk, are immigration offenses, drug offenses, and property crimes. That's really it. The rest are tangential. We're seeing prosecution of sex crimes go up as it's become more of a focus and more of a target. It doesn't mean that the level of crime has risen. It just means it's being enforced in that manner. So let's talk a little bit about the Supreme Court, right? Because obviously there's a Supreme Court battle going on right now. Hearings started today to replace the deceased RBG, Ruth Bader Ginsburg. Love her to death. I have a picture of her on my desk even. Very strong woman. So it'll be interesting to see how this plays out. But you'll notice that when we're talking about Supreme Court is in the news a lot lately, right? Because they do a lot of very important things. But how they got there was interesting, right? Because remember, the Founding Fathers gave them 2 paragraphs. The Founding Fathers basically said you have original jurisdiction, right? So you have original jurisdiction just refers to you get to hear the case, right? So the Supreme Court of the United States gets to hear the case before anyone else, right? If the matter involves issues between states, matters that involve ambassadors and foreign affairs, things along those lines. The Supreme Court is basically the trial court. They can hold trials. But generally speaking, the Supreme Court is a court of appeal, right? So, they dealt with some stuff after the ratification of the Constitution, but it was just really peanuts. And then, this is how well they were treated. So the Supreme Court met in a cloakroom in the U.S. Capitol building. They didn't even have their own building. It wasn't until the 1930s that we finally gave them a building. That's how important they were. They just met in a cloakroom. That being said, if you ever do go to the Capitol, the original Supreme Court chambers are preserved the way they looked. But yeah, that's when they were kind of unimportant, right? And we all thought they were unimportant. And then a case comes along called Marbury versus Madison, right? And what happens here is the court goes rogue and says it has the power of judicial review. And it is the final arbiter of the Constitution, right? Meaning it is the final interpreter of the Constitution. Which goes, wow, oh, okay. How do we deal with this, right? Because the Supreme Court just basically said, yeah, all cases that have federal issues, federal questions, we have appellate jurisdiction over. We can resolve if we want to take them. We will say if legislation is constitutional or not. We'll say if actions are constitutional or not, etc. Obviously, a lawsuit gets filed, and where do you think the lawsuit goes? It goes to the Supreme Court, right? So how are you going to tell the Supreme Court they can't do something? Congress could pass a law, but the Supreme Court could say, nope, that's not constitutional, we're still in charge. So Marbury versus Madison basically flips the Constitution on its head and makes the Supreme Court really important and lessens the importance of the other 2 branches of government, right? So the Supreme Court's kind of the final say, right? And I would argue that they are probably the most powerful branch of government because the only way to overrule a decision made by the Supreme Court of the United States is to pass a constitutional amendment, or the court can overrule itself. That's it. That's the only way you're getting out of a Supreme Court ruling. So that's the extreme power that it gave itself in Marbury versus Madison. So once it becomes a contender, right? Once it becomes really, really important, people actually wanted to serve on it. The original justices, they had to be begged to serve on the court. They thought it was embarrassing. And then suddenly it becomes really, really important. So how does the court select cases? It selects cases via what's called a writ of certiorari. And its selection is very, very limited. Now, it, in some cases, is required, keep this on, required to review cases. But most of the time, in other instances, the vast majority, the Supreme Court has discretion over what cases it will review. So if you get charged with a crime and bail is set for you, and you can't make that bail, you can appeal the bail, right? If you're at a magistrate court, you can appeal the bail to the district court. You don't like what you get there, you can appeal the bail to the appellate court. You don't like what you get there, you can appeal the question of how much your bail is to the United States Supreme Court. and the United States Supreme Court is required to hear questions of bail. Now, you won't get a full hearing from all the justices. Basically, there's a justice that sits over a couple of districts, and that justice will make the final decision. And you better believe you that it has to be to get a good ruling from a justice, you have to have a really good argument, right? If you're just bored and you appeal all the Supreme Court, they're just going to raise your bail. But if you can't make it anyway, like, who cares? Have some fun. But most of the time, they have discretion, right? And what they do is they have an informal, so it's not written down anywhere, it's not required, but they have an informal understanding. It's called the Rule of Four in discretionary cases. So basically, if 4 justices want to hear a case out of the 9, then the Supreme Court will hear that case. It will grant a writ of certiorari. If only 3 or 2 or whatever want to hear the case, then they won't hear the case, right? So it takes 4 out of the 9 to hear a case. That being said, how do you get to the Supreme Court? So cases can come from the federal courts, or if it raises a federal question, cases can come from state Supreme Courts, right? And the same is true in state Supreme Court. Like, if you don't like what your bail is set at, you can go all the way up to the U.S. Supreme Court. If your case raises a federal question or it raises a constitutional issue, then it can still go to the Supreme Court. Now, the Supreme Court gets a lot of petitions for its certiorari every year. We're going to look at a slide in a minute to show you just how many they get versus how much they take. Most of the time, you're not going to get them to hear a case unless it's really, really important. That being said, if they do take the case, they will either affirm the decision, which means the lower court's decision, we're upholding it and saying that's what it should be, or they will reverse and then remand, basically saying, we disagree with what you did, now do this instead and give a new trial or something along those lines. So again, they are a court, they do have these powers, but they are extremely, extremely powerful. And this is just the paths to get to the Supreme Court. We just talked about it. Magistrate court to district court of appeals to the Supreme Court. Then you have on the other side, trial courts of limited jurisdiction, trial courts of general jurisdiction, intermediate appellate courts, and then state appellate courts. Now, this is what I was talking about when I was talking about cases in terms of how many cases the people that have some kind of dispute going on want the Supreme Court to weigh in on versus how many cases the Supreme Court will actually hear, right? So the orange lines are the cases that are filed, right? You'll notice that in 2004-ish, we're talking close to 9,000 cases, right? And what has to happen in these cases is basically the law clerks kind of serve as the first line of defense. And then if it gets past the law clerks, then it can go to the justices, and then they decide whether or not to take the case, right? But think about it, at its peak, 9,000, and we're going back up again because if you have a case, like, why not, right? But you can see in the blue is how many cases are actually accepted. 1930s, 1940s, we have some, I mean, it's tiny, but there are some cases accepted. 1980s and 1990s is when we have the most cases accepted. And keep in mind, it's still very low. We're talking maybe 100 cases, right? In 1980s and 1990s, maybe we're talking 200 cases a year, if that. But if we look down in 2010, 2007, what we see is the trend is going down, right? So the Supreme Court's only hearing roughly 100 cases a year and is now receiving 1,000 petitions a year. So your chances are not great of getting your case heard by the Supreme Court. But that's what we're talking about when saying, like, you can file and ask the Supreme Court to take your case, but they have discretion, right? They can do whatever they want. And usually they limit it to 100 cases roughly in that realm. There's no hard, fast limit. It's just kind of what comes before them. Now I want to talk to you briefly about the state court, right? So the state courts, we can't look at each, and we could, but we're not going to, each court or each state, because each state is, it's complicated, right? The feds, it's a fairly easy system to follow. In the states, they're complicated, and no two states are exactly alike. And the names of the courts vary very widely. So for instance, not all states have an intermediate court of appeals, right? So that would be the same thing as the circuit court of appeals for the feds. So New Hampshire doesn't have an intermediate court of appeals. So you go to trial court, and then if you want to appeal, you go to the New Hampshire Supreme Court. And the New Hampshire Supreme Court has to hear the case. So under the law, you get one appeal as a matter of right. So New Hampshire has to hear the case. Some courts have a bifurcated appeals process or Supreme Court process. So Alabama and Texas both have bifurcated appeals processes. Basically one for criminal and one for civil. And there will be maybe two Supreme Courts. One deals with criminal and one that deals with civil. Now, the question is why? It's honestly to speed up the death penalty. So one court can kind of specialize and then doesn't have to deal with this stuff in the other courts. Now, that being said, some courts have really misleading names. All right, so when we think of Supreme Court, we think of like the US Supreme Court, or if we're saying like Missouri Supreme Court, we're saying like that's the top court in the state, right? That's generally true, except for New York. New York has decided, and decided a long time ago, that they would call their trial courts, the courts of general jurisdiction, Supreme Court, right? So most states call this circuit courts or district courts. New York calls it the Supreme Court. And then from the Supreme Court, you can appeal all the way up to the New York Court of Appeals. And the New York Court of Appeals is the Supreme Court, basically, of New York. It gets confusing, it gets jumbled, but if you ever see like in something in New York and it comes down from the Supreme Court, just know that's a trial court, right? It's not an appellate court. It doesn't make sweeping decisions. It's just a trial court. Most states also have specialized courts. So in addition to, and they're very limited jurisdiction courts. So a lot of states have adopted drug courts, and all they do is deal with drugs, right? And oftentimes they're designed in such a way as to make to help, I would say, defendants, right? Especially in drug court. The idea is in drug court, you have criminal charges pending, right? But drug court will basically erase the charges if you complete their program. And completing their program is not fun. I mean, you're talking like drug tests every other day. You're going to court often. You're going to NA or AA or whatever. You're getting searched all the time. But if you complete it, you complete drug court, you don't have anything on your record, right? And the idea is, if we just, and drugs are the most common issue, right, that we deal with in the criminal justice system. And so the idea that we're sending people to jail for possession of marijuana, and usually there are possession charges, like distribution gets a little bit more complicated because then you're like dealing it. But if it's just like possession, we're going to say that, I mean, why are we going to send you to prison for possession? It doesn't make any sense. Because guess what? You can get drugs in prison. They're more expensive, but you can get drugs in prison. So, you know, why are we punishing them if they haven't done anything that hurts other people besides themselves? Right, so that's the idea of drug court. And again, if we're talking you're distributing, then that changes our analysis completely. Courts, and if we kind of look on the civil side, we might see specialized courts. There's family court, right? Family court just deals with family issues like divorce, custody. Sometimes family courts deal with juvenile delinquency. They may hear juvenile trials from juvenile crimes. But again, it's all kind of tailored towards family disputes, leaving the court of general jurisdiction to take important matters. Not saying that like a divorce custody issue isn't important, but in the grand scheme of things, we'd rather have the Supreme Court of New York, or basically the trial court, focus on like murders and stuff, rather than having to deal with divorce and drugs, right? We want them to give you the most due process as possible. And we also like people to specialize, right? Because if a judge just hears divorces all day, he or she kind of becomes an expert, right? And can mediate them in a very good way. Now, that being said, all state courts do share one thing in common. They have a multi-tier system. So it's similar to the structure of the federal courts, and each tier has a separate function or jurisdiction, right? So if we think about New Hampshire, you have the trial courts, then you have New Hampshire Supreme Court, New Hampshire, right? There's no intermediate court of appeals. But there is a bifurcated, there is a multi-tiered system, right? So there's not just like one court and that's it. If you think about Missouri has circuit courts, district courts, so general jurisdiction, limited jurisdiction, has Missouri Court of Appeals, right? So appellate jurisdiction, and then it has the Missouri Supreme Court, appellate jurisdiction as well, right? And the Supreme Court is the highest court in Missouri, unless there's a federal issue, and then in that case you can appeal to the Supreme Court of the United States. So they all are multi-tiered. There's no just one like, okay, you're guilty and good luck trying to appeal to the US Supreme Court. No, there's always some kind of tier, because you are guaranteed as a matter of your constitutional rights to one appeal. Anything after one appeal is discretionary. Right, so the Missouri Supreme Court, because there's an intermediate court of appeals, it doesn't have to take a case. Just like the Supreme Court of the United States doesn't have to take a case. The intermediate court of appeals in Missouri, the Missouri Court of Appeals, has to take the case, right? Has to hear the arguments, because you get that as a matter of right. So that kind of gives you an idea of we've seen charts of how states and the feds, they're layered, right? And the idea is due process, as much due process as possible. We want to make sure we're sending the right people to the right places, we're coming out fairly, et cetera, et cetera. So we'll wrap up with the courtroom work group, right? So the courtroom work group consists of, well, people who work in the courtroom. So this shall all be review for you, but the person who's in charge in a courtroom is a judge, right? So the judge is technically responsible for the honest, impartial, and equitable administration of justice, right? So that's what we say. In reality, they act as both arbiters and administrators, right? So arbiters are basically dealing with issues kind of informally. If you ever go to like a court and it's like a district court, you're gonna be bored out of your mind, because the judges, they're trying to like do things a little informally, but really the judge is kind of an administrator. Because we're gonna see that the prosecutor is probably the most important person in that room, not the judge. The judge deals with like calendaring and making some decisions here and there, is what it is, right? That being said, all Article 3, so these are federal judges, are appointed by the president and confirmed by the Senate. So not just Supreme Court justices, but every federal court justice, with the exception of magistrates. Magistrates, remember that's that limited jurisdiction court, they are appointed by the district court or the general court general jurisdiction court, judges. They get together, they agree on someone, and they select them to be a magistrate. Now, compare that to how most state, county, and municipal judges. Most state, county, municipal judges are elected, right, or appointed. Now, in order to be elected, you don't have to have a law degree. You can just run for state judge or judge in your county, and you may get elected. That happens a lot. I know it's funny, is in Missouri, we elected, I don't know why, but we elect coroners. Like, okay, why? Right? Like there's no reason for it. But to be a coroner, and we did this in my county several times, we elected people who weren't doctors. Like literally, one time we elected a guy who was an electrician to be the county coroner. So again, that's where we have some problems with elections. But you know, it is what it is. Or they're appointed, and if they're appointed, they're usually appointed by the governor or Supreme Court, something along those lines. So then we have prosecutors. Now, prosecutors, they are the chief law enforcement authority of the community, right? That's why the U.S. Attorney General is the chief law enforcement officer of the land. Now, it's kind of weird to think about it in those terms, because when we think about law enforcement, generally we're thinking about the police, right? Well, prosecutors in most states do carry badges. They are legitimately a chief law enforcement officer, right? But they're officers of the court. So can they go on a raid of a house? Generally no. Can they make an arrest? Generally no. These are officers of the court, but they're law enforcement officers. They're the chief. They decide what police do, how police are going to do it, what they're going to focus on, all that jazz. So prosecutors, this is why they get important. These 2 points is they decide as a matter of what's called prosecutorial discretion what charges will be brought. So they decide if they're going to proceed for murder 1, right, or murder 2, if they're going to go for manslaughter, if they're going to go, whatever they're going to go for. They get to decide, right? So this is assuming that the grand jury isn't deciding. Federal-wise, we have grand juries that decide. States, some have grand juries, some have prosecutors, some have both. But a lot of times it's just the prosecutor deciding what charges to bring, right? So they get power in that sense, right? Because automatically they can kind of start threatening the defendant with, I'm going to ratchet up the charges, right? Like, or if you plead guilty, I'll lower the charges. And that's where this comes into play. So prosecutorial discretion involves the decision to prosecute, like what they're going to prosecute, or they can enter a nolle prosequi, which is basically a null prosecution, meaning we're not going to prosecute, or they enter into, most commonly, plea bargaining, right? And so plea bargaining is basically just an arrangement, right, between the prosecutor and the defendant, and the defense counsel and the defendant. Oftentimes, prosecutors will abuse their discretion and bring the most severe charges they can, knowing that they're going to plea bargain down to something less severe. But they get to come out in the papers saying that they're doing this, right? And they got and a guilty plea counts as a win for prosecutors. So 90% of all felonies are plea bargained, and almost 100% of all misdemeanors are plea bargained, right? So they have a lot of control, and they also want to look good. And why do they want to look good? Is generally they're elected. Some states they're appointed, but most states prosecutors are elected, right? And that raises really big issues because you don't have to have a law degree to be a prosecutor in those states. And agendas become very scary, right? So you need to know how your prosecutor feels about certain topics before you vote for that prosecutor, right? So again, they kind of have incentive to show that they're tough on crime. In reality, they're going to come down to some kind of plea bargain. Usually it's going to be like probation, unless it's something really severe. Courtroom work continued. We have defense attorneys, right? They are mainly limited to pretrial phases because most cases are plea bargained, right? We very rarely ever go to trial. We just plea bargain and engage in motion practice. And motion practice is basically the exclusionary rule, saying like this gun shouldn't come into play because it was obtained illegally, and then that changes the plea bargain, and it's just kind of this back and forth, right? Now that being said, the defendant has the right to be represented by counsel under the Sixth Amendment. Now, we generally say prosecutors, judges, and defense attorneys are the courtroom work group. I argue that the accused, the defendant, is also part of the work group, right? And this often means a public defender. So when you get time, click on this link. It takes you to a really great video. It's a funny one, but it takes you to a really great video showing how problematic our public defender system is. It is in a state of crisis. So please be mindful of that. There's other courtroom regulars that aren't necessarily considered part of the work group, but they're talking like bailiffs and sheriffs, right? So the sheriff's deputies, they're responsible for court security. You have the court clerk, who basically calendars everything, right? Court clerk kind of runs the show for the most part. Even though like we say judges do, but the court clerk is, if you get in with the court clerk, you're good, right? Because they'll call your case first, so you don't have to sit there all day. So the court clerk there, court reporters are stenographers, right? So people sitting up front. You have witnesses, coroners, the medical examiners, and auxiliary court personnel, which are like secretaries and janitors and whatever you want to talk about. So we'll finish with this. This is the courtroom work group, where they generally sit, right? So you have the jury 4-person on the left, the person with the burden of proof, which is the plaintiff or the prosecutor. They sit closest to the jury. The defendant sits on the other side of the room. The court clerk is in the middle. Usually elevated is the judge in the middle. To the judge's left-hand side, there's a witness stand. To the judge's right-hand side, we usually have a court reporter. And then standing right beside the judge will be a bailiff. And they kind of act as the intermediary, right? So then you have this big blue bar right, at the top of the screen. And then you have spectators. So when a lawyer, or when there's a difference between lawyers and attorneys. Lawyers, basically, they've studied law, they don't practice, aren't barred. Attorneys are barred. What I mean by barred is they have the ability to go into court and practice law, right? So we call it the bar exam that you have to pass in order to practice law. Where does the term bar come from? It comes from this blue bar up here, right? You no longer are a spectator. Now you can pass the physical barrier, the bar, and you can come in and be a prosecutor, if you're a prosecutor, defense attorney, or whatever it is. You have the ability to come into court and argue on somebody's behalf, right? So that's kind of how this all plays out. It's a very general, very, very general overview of how courts work and how courtroom personnel work. And again, if you want to learn more, and it is more exciting than this, I promise, as to like what everyone does and what court you go to, if this happens or this happens, take judicial process with me. It'll be a great time. That being said, thank you for listening. And if you have any questions, always feel free to reach out and email me.